Hello everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today I am going to discuss about Hindu law. So first I am going to give the introduction concerning with Hindu law. This world contains a population of 8 billion. Out of that, 1.38 billion folks sleep in Asian nation presently. India is a nation where different religions like Hindu, Muslim, Sikh, Christian and Parsi live along, which shows secularism. In India, there are two types of laws are mentioned. First is general law and the other one is personal law. General law includes the IPC, Constitutional Law, Indian Contract Act and the plenty of additional. And therefore the personal law includes Hindu law, Muslim law and plenty of additional that we will discuss the Hindu law during this video. So what was the origin of Hindu law? In Dharma Shastra, there is no word like Hindu. It's a distant origin. The word Hindu came into existence through Greeks. This nation came to be referred to as Hindustan and its people as its folk as Hindu as within the history. The word Hindu not solely specifies a faith, however it conjointly specifies a nation primarily. The Hindu law has been adjusted through centuries and been co-jointly living since last 5,000 years and has co-jointly continued to control the social and ethical figure of Hindu life by following the various parts of Hindu cultural life. What is the concept of Dharma? We know that the word Dharma is set to Hindu law. Let me elaborate to you. The word Dharma per Hindu mythology suggests that duty. Watching the context and therefore the non-secular references, Dharma has completely different meanings, rather like the Buddhists believe that the word Dharma suggests that solely a universal law that is extremely a lot of essential, and therefore the Jains and therefore the Sikhs believe that it's solely a spiritual path for the success of the reality. According to the Hindu jurisprudence, Dharma suggests that duties in many ways, rather like the social science duties, legal duties or religious duties. Through this context, we are able to say that Dharma will be remarked because the thought of justice. Who are Hindus? Hindus are people who are Hindu in any form such as Jain, Sikh and are born to Hindu parents. The Supreme Court of India in the landmark case of Shastri versus Muldas directly defined the term Hindu. The case is related to the Swaminarayan temple in Ahmedabad. There are a group of people called the Satsangi who were heading the temple and they restricted non-Satsangi regions to enter the temple. They stated that Satsangi is a different religion and they are not hurdled by Hindu law. The Supreme Court of India held that the Satsangi, Arya Samajis and Radha Swami, all these are included to the Hindu religion because they are derived from Hindu philosophy. What are the rights of daughter on property according to Hindu law? Now daughter has equal rights of property under Hindu law. A three-judge bench, Justice S. Abdul Nagir and Justice M. R. Shah, headed by Justice Arun Mishra, said daughters must be given equal rights as sons. Daughter remains a loving daughter throughout life. The daughter shall remain a co-partner throughout life irrespective of whether her father is alive or not. Justice Mishra said daughters have to be given equal share of co-partnery rights in share of property like the son. The bench also held that rights under the amendment are applicable to living daughters of living co-partners as on September 9, 2005, irrespective of when such daughters are born. The provisions contained in substituted Section 6 of the Hindu Separation Act confer status of co-partner on the daughter born before or after the amendment in the same manner as sons, with same rights and liabilities. Since the right in co-partnery is by birth, it is not necessary that the father of the co-partner should be living as on September 9, 2005, the bench ruled. The top court, however, said that a registered settlement on partition suit decreed prior to December 20, 2004 will not be reopened in a move to stop reopening of earlier settlements. The Supreme Court had earlier given two conflicting judgments in two cases, Prakash v. Puklavati 2015 and Dhanamma Suman Sarpar versus Amar in 2018. In Prakash v. Phulavati 2015, a bench comprising justices Anil R. Dev and A.K. Goyal had said the rights under the amendment are applicable to living daughters of living co-partners as on September 9, 2005, regardless of when such daughters are born. In the second case of the Namma Suman Sarpar versus Amar 2018, the bench comprising Justices A.K. Sikri and Ashok Bhushan had said that the share of the father who died in 2001 would also devolve upon his two daughters who would be entitled to a share in the property. that's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.